Hello, world. This is Hello Chaos, the podcast about the ups and downs, ins and outs, highlights, and low points of entrepreneurship. We celebrate it all. And thank you so much for joining us. I am Jeno.
Oh, you're not going to say your full name?
I am Jennifer Oladipo. A little rusty, I guess. Okay, let me see that one over.
It's okay. We'll just keep going. That's the fun part. This is Jeno, a.k.a. Jennifer Oladipo.
Oladipo all day, every day.
And I'm Jennifer Sutton, a.k.a. JJ. And I love having in-studio guests. And today we've got Doug Lineberry from Burr and Foreman, attorney at law.
Back by popular demand. I wasn't kidding.
Yeah.
Yours was one of the most popular. I heard the most about it. And I'm just so glad to have you back.
IP protection, trademark protection.
We really need to get y'all new friends.
Yeah.
So.
But yeah, no, you were a very popular episode.
Yeah, because the IP stuff is scary. And so brought you back today.
And confusing.
Yes.
Sure.
To talk. I think last time, folks, check that one out. You talked about just kind of a general when to think about your intellectual property. What are some of the things that could, happen? Who doesn't think they need to think about
the difference
IP?
between trademark and copyright, the steps that you need to take. When do you need to engage a lawyer, and what type of lawyer do you need to engage at those stages? So that's in that first episode.
Yes. And today we're here to talk about, well, maybe if you don't follow all those tips, or if something goes wrong.
Yeah.
Or if you do follow those steps, but you still...
And something goes wrong.
Something goes wrong, right?
Yeah. So enforcement, so I guess what? It's offense and defense, right?
It is.
That's what we're talking
Absolutely.
about.
Absolutely. X's and O's.
X's and O's. Okay.
Yeah.
So offense, defense. What do you deal with first? Offense, I guess.
No? I'd say let's do defense.
Let's do defense first.
We'll
okay.
talk D first, and then we can go O.
Little D?
Because I think the little D is going to
Oh, so sorry. I am so
Good job,
sorry.
JJ.
That
Just
was
went X-rated.
Wow.
That's awesome.
I mean,
That's awesome.
We lasted like 2 minutes.
Straight out of the gate.
This is why we have an E rating on Spotify. This is why.
All right. So when we're talking about little D, oh my Lord. But no.
I'm so sorry.
No. But Jeno and JJ, y'all do raise the right points, because if you were to get a cease and desist letter in the mail, you're going to have a gut drop. If you don't have a gut drop, you're probably not in the moment, because you've got someone who has sent you something and might even be served on you. You can have a service processor come up and boom, here's a complaint. Boom, here's a certified letter. Nobody wants those surprises. All of us want the day-to-day to be kind of hey, I go do my thing, I come home, it's chill.
Right.
What could happen, though, is you're going to get a disruption. This disruption could be in the form of, hey, I have a complaint about how you're using your intellectual property. And it may be a complaint of, I think you're using my trademark. I think you're infringing my copyright. I think you're infringing my patent, or maybe you're using my trade secrets. There are a lot of different slices of pie here. So you're going to get this letter. And what happens next is, to quote the great sage.
Can I ask a quick question?
Jenna.
Is it always physical letters still?
Sometimes you can get an email.
Okay.
It has advanced to the 21st century.
Okay.
But typically, if you've got an attorney, we're still old school.
Yeah.
You may get an email, but you're definitely going to get a letter.
Well, the reason I ask is because there's so much stuff in our inboxes that
it goes to junk.
I mean, do people ever miss these things?
Absolutely they do. And again, I'm bad. Checking your emails, especially on a hectic day when you're running around doing things, it's tough. And invariably, you will skip one. And so, guys, if you do have one, a lot of the times, if I send one out on someone's behalf, I put a time limit in it. I'm like, hey, you need to get back to us by X. A couple things could happen. Maybe this is a hollow threat and they don't care. Maybe my client might be irate and be like, hey, if they don't get back to us, we're filing a suit. And so we really do need to be cognizant of this. Treat each of these as kind of like a loaded gun.
Yeah.
And let's figure out what to do next. Now, in the words of that sage, Douglas Adams, don't panic, because there are a lot of different avenues here. You're going to open this letter. Let's go trademark just to be easy. Somebody says, hey, you're using Hello Chaos, and I don't think Hello Chaos is your mark. I own this mark. I'm in North Dakota, and I've been using this on a podcast for years. So you're going to see that at first. And, of course, you're going to be offended, and you're going to get angry, all the steps of grief, as it were. No, seriously, you will, because you're going to go through it. Now, I have a lot of clients coming to me at the mad stage. Like, I cannot believe this. And some of them approach you with the what I do stage. stage, and some are cavalier and it's going, all right, whatever, let's see. But yeah, those are the dangerous ones. But usually the most fun, but also dangerous. But what we want to do is understand that, hey, it's an academic exercise. We need to look at what's been alleged, and is there any truth to it? And again, we'll talk about the offensive aspect of it too, but the defensive aspect of it is, did the other party who sent you that nasty gram, served you that letter, sent you that email, have they done their homework? You need to go back and you have to know your own intellectual property. Let's kind of start with that as a base, because if y'all been using Hello Chaos, let's say for 5 years, and you've got the ability to show, hey, I've been using it for 5 years, and you go look at this other side, and maybe they've not been using it 5 years, or maybe they just filed a federal trademark, that gives you some options. Another thing is, how similar are their uses? Let's say that the Hello Chaos in North Dakota is for mining equipment. And they're like, hey, we're Hello Chaos Mining, and you're Hello Chaos the podcast. Your retort's going to be kind of a, huh? And it's like, I don't understand.
We're in different industries.
I'm not selling conveyor belts. I'm not selling mining equipment.
Because the main idea is that they're alleging that by using their trademark, you're impacting their ability to do business.
That's right. You're impacting their brand. You're somehow diverting sales. You're causing them damage of some sort. And y'all, if it's very disparate goods or services, your first response back might be like, but to do that, and I know it's Latin for no. But to go get that, don't do this yourself, because there's a horrible little thing in evidence called admission by a party opponent. And that means that if you get on the phone and start screaming back at them, or if you start angry typing, we're not going to do any of those. First thing you're going to do is go get a drink of water after you read the letter.
And then call the attorney.
And call an attorney. And I know it's an attorney saying call an attorney, trust me, because if you call North Dakota, and let's say they are a podcast, and you're like, I've done this, and I've done that, and I've been using it this long. What if they're recording that? So we want to make certain that all powder is kept dry here. We don't want any off-the-cuff reactions. We definitely don't want an emotional response. What we want to have is a thought-out, coherent response that addresses their issues. And it may be as simple as going to an attorney, them reading the letter and being like, man, what's this about? And checking into it, seeing what the other mark is, seeing what their business is, etc.
What's the argument like?
That's right. That's right. What are our counters to this? Are there any? Lo and behold, maybe this person's been using it, but there are a couple different things too. And we'll switch to offense for a second. If someone were to hit you with this, one thing you ought to look at is say, this is my trademark. I've been using it. How have they protected that mark? There's some very poignant weapons. If they say, for example, a registered federal trademark, you can file what's called a cancellation proceeding. I'm in a couple of those now. And unfortunately, it's kind of a poking the bear or poking the dragon situation. Make certain you got your powder dry. Because if you're the person sending out this letter, what if you send it to someone who's been using the trademark first? What if you send it to someone who's like, I've got a big war chest and I don't want you messing with me. Maybe I'm going to attack your mark and get it canceled. So this has to be done in a coherent, and I mean, Jenno, I think that's the exact right response. Whoa, I didn't see that coming. Because I've had clients before who are like, I've been using this mark for X many years. You tell me what we need to do to fight it and we'll fight it. That's not what the person on the other side wants to hear. And especially in the, hey, we've been using this a lot longer than you. And Lord forbid, you could try to beat them to the trademark office that they've not filed. I mean, there's some definite ways that you can do this.
And it's not necessarily like names and logos, right? It can be.
Oh, sure. Trademarks can protect sounds, smells.
Oh, so like the Netflix little.
Yes. Oh, okay. Exactly.
Okay. Or the Intel.
Yes.
And the NBC.
Oh, better yet. You guys walk into a Verizon store and just smell the air.
Really?
There's a trademark on the smell in a Verizon store. So guess what? Hey, if Hello Chaos starts doing this, hey, we smell like a Verizon store, you're going to get a letter from Verizon going, why do you smell like a Verizon store? Or guess what? If you guys start making motorcycles and you're like, I sound just like a Harley, you're going to get a letter from Harley Davidson going, that's our sound. You need to step off and let's talk damages.
I love this.
So I mean, y'all, it really is sort of heady stuff. You're just like, oh my gosh, what all does it protect? But JJ, you're right. It's not just a logo. It's not just the words.
A name.
Or a name. It's a lot of other different things.
Is there like design, like close to a designer using same colors? Is that something?
Sure. John Deere green. None of us can set up a tractor supply company and paint it John Deere green. That's protected. The Boise State football field. Guess what? We cannot go over to JL Man, paint it that color blue, and start having football games. We are going to get a cease and desist from them. And so that's kind of our defensive statures. Hey, are we the wrongdoer here, or are we in the wrong, or is this just something that we need to negotiate? Because I'll remind you all this little fact, 99% of all cases settle. And what that means is they reach some middle ground.
Okay.
And so again, that's why we harken back to Douglas Adams. Don't panic. You know, that maybe they're full bore, we're going to fight you to the end of time. That's the 1%ers.
Right.
Most of the time, they're like, hey, let's figure out something so we can both coexist. Sometimes it's a you go away, but most times it's a, all right, what can we do to tolerate each other?
Oh, interesting.
So
there's hope.
There is hope. Now let's talk, but there absolutely is. So let's talk offensively for a second. So you know what to do if we get that letter?
Yeah.
Run screaming to an attorney after you panic like I told you not to.
Yeah.
And so remember,
Drink the water.
That's right. Drink the water.
Take a
Type
deep
back
breath.
angry. Remember all these rules. Just
And
put an
only
negative in
type
front
it
of
to
That's
your
right.
lawyer.
Call and be recorded having a tirade to the other side. Your attorneys love that. It's so helpful.
Threats? Should we add threats to
I
the
think
mix?
threats are great.
Yeah.
Threats are good. I know where you live. I'm coming. You know, it's like, have you ever seen that movie with Liam Nelson in it? I'm coming for you. You know, it's like, no. I prefer you didn't do that. But if you did, you're going to be building a lot more. You will get what is called the rack 1 rate. You don't actually want to understand what that means coming from an attorney. So trust me, don't panic. Don't respond. Go to your attorney after having a nice, cool sip of water. But let's reverse it. Okay, we see a Hello Chaos for a podcast in LA. We're like, we're not exactly cool with that. Said, you know, we're a podcast, we're Hello Chaos, we're out here on the East Coast, but we're growing. And our plan is to be nationwide, eventually worldwide. You know, that's what we're going to do. So there's an onus on us to protect our mark. And you're like, what do you mean onus? Now, JJ, you'll love this. It's not a double entendre. It's actually a legal term. Naked licensing. And what that means is if we let that LA firm, that LA podcast do their thing and we don't say anything about it, after
We've
a while,
kind of given them permission to exist.
Exactly, because it is called a naked license, meaning it's not actually written down. There's not a contract for it. You've just turned them loose. And a lot of people do that because, hey, it takes time and attention and money to go after these folks. But here's the problem. Let's say we've waited and we knew of them, and now all of a sudden this got real. You know, we become one of those 1% cases that starts to litigate. You're going to be deposed. I mean, JJ, you or Gino are going to be sat down. It's like, when did you know about us? What did you know? How long have you known it? And it'll be somebody like me who comes across as so disarming, and we'll just talk and we'll have a great time. And I'm going to comment on, oh my God, that shirt is awesome. Where'd you get that ring? And trust me, that we've got a whole litany. The good ones of us come across as human. It's weird. Okay? But you guys will be put under that microscope. And so when we're offensive, we need to remember offensive is both I'm going to get you and I'm going to be hostile about it. So we have to protect our marks. We have to do it in a smart way, though, because let's find out that the Hello Chaos has been out there for 15 years. Guess what? Maybe they turn around and attack our mark with a cancellation or an opposition, depending on where it's at in the process of the trademark office. But really what we want to do is let's get our powder dry. You know, let's do this intelligently. Just like getting that letter, sending that letter is just as important. Because if you ever receive a letter and it's specious and it's wrong, the person who receives it's going to be like, well, this is crap. And then you explain why it's crap. And the attorney on the other side's like, I really wish I'd known some of this before I'd sent it down.
Yeah.
Okay.
Like I didn't do my homework, or my client didn't
I didn't do
inform me.
homework, or the client didn't tell me all of it, or maybe.
So then should business owners, I mean, how do you, because how are we to know if every other startup that's on the West Coast that's, you know, just suddenly has designs on growth and we're suddenly in each other's territory
Beautiful.
or whatever?
That's a great question, Gino. And you're going to find it organically. You know, we have what's called the discovery rule. You know, when did you find out about it? You're not assumed to be omniscient, you know, but what you can do, there are certain programs we can hire to look at trademarks that are being filed. I've got some clients that do that. If someone tries to file on a mark that is close to one of their marks, we're pinged. And it's told, hey, we just had an application filed at the trademark office for XYZ. It's very similar to your client's XXX or YYY or whatever the mark is. And so there are ways that we can anticipate it and see what's out there. You can reach out to them early. I just had one, I think we'll get it resolved this week, but ended up very, very easy. The person found out about my client's mark and then actually changed their mark to something else. And I'm like, wow, easiest of all worlds. And so now we're working with them on transfer of the rights, transfer of everything else, so that my client, the senior user, really doesn't have to have much heartburn. And indeed, they're going to have a call, the two disparate parties are going to have a call to see if they can work together. You know, that is definitely a way.
Because they're in the same category, because of whatever?
They are in a particular industry,
Yeah.
and they're both in that industry, and they want to open up similar venues. And so I'm being clandestine, I know.
No, I get it. Yeah.
But, you know, hey, guess what? They're going to have a conversation with each other and see if is there a way for synergy as opposed to warfare.
Oh, to actually work together.
Absolutely.
Oh,
You know?
okay.
So that's That would be the kind thing.
That would be the kind thing.
The economical thing, the common sense thing.
I mean, to even just have the discussion, right? Oh, is this a business opportunity, actually?
That's right.
Yeah.
And one thing I will tell everybody listening to the podcast, don't be afraid to haggle. Oh my gosh, we Americans are so terrible at haggling.
Yeah.
And it's like, look, I realize going to McDonald's trying to haggle for a Big Mac's a little awkward. Try it, but in a legal situation, do it. As Yoda said, there is no try. In a legal situation, you haggle. You go out, you figure out what terms you want, and again, you ask for 10 to get 5. Remember that adage. Ask for 10 to get 5. Don't go in there thinking, okay, I'm honest, John, and this is exactly what I want, because the other side will view that as your 10, and they're going to cut it in half. And so you need to understand where your fat and happy is and how much of that you can have cut off without freezing to death. But this is something, guys, that we just, as Americans, we don't do. And there are attorneys who are not very good at it either. And you need to sit back and think, hey, what are my middle grounds? And you need to address this with the other side and say, hey, tell me where we can live with each other.
Right.
And then they'll give you back their 10. And you got to figure out your 5. Or if they ask you and say, hey, I want yours, you give them your 10, knowing that you'll accept a 5. And so you figure out how to deal with that. But that should be the way we would handle a lot of this stuff. Now, granted, there's times when you get a nastiness. Let's talk domain names, for instance. If someone were to open up a hellochaos.net.org, whatever, that y'all didn't have, there are ways that we can make them forfeit that. And that is one of those situations to where you're not okay with them doing this. And you're not going to try to seek a middle ground because you're like, hey, this is such a unique name. You probably bought it, A, after we started being out in the public, and B, solely for the purpose of trying to get us to purchase it from you, called being a troll, which is not cool.
That's right.
Yeah.
And so what you want to do is to realize, go to your attorney, let's figure out what the situation is. Because if there's a Hello Chaos that's been out there for 20 years, there are things we can do. There's a concept where you could file a federal trademark and you simply lock them into a little bitty spot. Maybe you'll figure out how to coexist, and to figure out you can do this and I can do that, and never the twain shall meet.
Right.
And maybe you merge at some point and become partners. Who knows? But there are a lot of different ways to sort of skin the cat. But one thing we always want to do, either offense or defense, is to make certain that we're protecting those marks. And I don't mean just filing them and getting them out there. I mean, if we see a Hello Chaos on the coast,
to defend them.
Well, yeah, we need to be like, hey, this is my mark, and I don't want to lose it due to naked licensing, or I don't want to have a situation where maybe I've not fully protected my marks. I see that these guys are out there and sort of nascent. Maybe there are actions I need to take right now to protect that mark.
So you've got my wheels turning now, Doug.
Oh, sorry. I didn't mean to click machine gears in, but yeah.
So if you didn't do your paperwork, let's call it, but you've legitimately been using it and, operating as a business and everything like that, you're saying there is some recourse.
There are.
Perhaps.
There are.
To kind of walk backwards and go, okay. Yeah. I didn't know I needed to protect these things.
Sure. And now there's also some unfortunate situations. They can have the fishbowl. Let's say that we're Hello Chaos and we didn't file, which we have. We filed. We're good. But let's say we hadn't, and that there is a 20-year-old Hello Chaos that's everywhere. And they filed a federal trademark, but they're younger than us. We're 20 years old. They're 5 years old.
Right.
They roll in and they've got the ability to lock us into a little bitty fishbowl and say, hey, you guys are now here. And everybody will swear, the internet covers everything. Courts aren't that mature yet. It's going to count where you're advertising, where you're doing physical usage, where are we at, where expenditures being made, etc. Much smaller than most people who would say, like, I've got a podcast, therefore I cover the planet. No, you're probably restricted to Des Moines based on what your advertising budget is. The podcast that you've got 100,000 listening to, doesn't matter if they're in Tokyo. It's really going to matter on what have you done locally to get that mark out there and to protect it. And that is still where the courts are locked.
Very interesting. Gotcha. So they could effectively still sort of put you.
They trap you.
Yeah.
They trap you. And that's why you file and get federal protection, because that gives you the better card in that situation. Now, granted,
the offense.
It does. That is the best defense is a good offense, as people say. But I'm with y'all on this. It's like we have to be knowledgeable about it. But again, don't panic. We're going to have to go back and be honest about it. Keep track of when you create your marks. That's a good way to be able to say, I was using this in 17.
Right.
Look, here is this flyer that I put out saying, hey, come down to the west end of Greenville for one of our podcasts. Having that sort of material at hand is so easy. And it happens with sophisticated clients. I've had clients before who will, interestingly
like big corporations.
Big universities. They will come to an attorney and be like, I need to file this. You're like, all right. And I send back a list of questions of, tell me how long you've been using it. And, I've had clients who've been using a mark for close to 20 years, and just filed for it. And you're like, holy moly. And I'll do the search on that one, kind of sweating on their behalf, because I'm like, there have been 16 years of trademarks filed between this and now. You know, and sometimes you come back with we need to file this thing yesterday. Gotta go. And sometimes you come back with I have bad news for you. And it might not be an exact
can't file
mark.
this.
That's right. You can't get this mark that you've spent all this time on. So y'all, that therein lies the good offense. You know, file those marks, be aggressive about that, and be cost conscious. Don't file on every little word you ever think of.
Right.
But if it is your company's McDonald's Golden Arches, protect it. Because if you don't,
Or your sound.
Or your sound,
your smell.
or your color, or your smell. That's absolutely it. If that is your baby and that's how the consumers recognize you, protect it.
Yeah. So I want to get into a little bit of back to those 7 stages of grief, you know, because now that we know exactly like what to do, how do you talk people through that when those things happen?
You know, first thing you do is Meet or Zoom. This is not a telephone thing. You need the client to actually get familiar with you, because guess what? You're going to start digging. You're going to start asking a lot of questions. And you're going to say, hey, I need to know it. So build a rapport with whoever your counsel is. I know it sounds so silly and touchy-touchy, but it's a great thing to do, especially in an age where everybody still likes to be a keyboard warrior. You know, this is the person you're asking to protect your brand. Be comfortable with them. You know, sit down with them, understand that they take it seriously. So that first step is communication. And again, be open about it. Tell us if there's hair on the mole, please tell us. Because if you don't and you try to hide it, the other side may find it out and throw it back. And then, unfortunately, we're on our back foot pedaling because,
you can't make your argument.
What kinds of things do people try to hide from you?
You know, not try to hide. You know, sometimes let's go with the innocence, the naivete approach here.
Forget to mention to you.
That's it. That better way of putting it. Forget to mention conscious.
I love how Jenna is always like the nefarious, side.
Jenna, law school awaits you if you want to go there. I'm just saying. The avenue's always
open.
Well,
you know what? Half the people in law school when I was in journalism school were like, yeah, I thought about journalism school, and half the J school kids have been thinking about law school.
That's right. It's just kind of an exchange program. You're like, all right,
we were always
the
ones to shut down the parties, too. The last 2 drinkers were the J school and the law school. I don't know what that says about society, but
alcoholism and conscious narcissism. But no, y'all have got the right thing. What do they try to hide? And that's really, it's an awesome question, because don't try to hide something from your attorney. It all will out. You know, for patents, for instance, one thing that somebody might hide is, hey, you know, I've been selling this thing for a while. Because for a patent, if you've been selling it more than a year, you can't protect it. And if you go to your attorney and you're like, hey, I've been selling this more than a year, the attorney's going to be like, well, unless you have some significant changes over this particular model, you can't get a patent on it. So somebody might hide that one from you and be like, oh, no, never hit it. But if you have a competitor comes out who challenges your patent, they're going to find it. You know, for trademarks, hiding it, you know, where'd you get your idea for this? You know, what if you are intentionally trying to copy somebody else's mark? You know, what if you were like, yeah, man, I looked at it, because if you've had conversations with folks in your company about, oh my gosh, you know, look at that McDonald's arch, it's so elegant, we should do that for us. Let's make ours look like it, but we'll make it red and angular. Well, guess what? If you've been telling everybody, hey, I want to look like McDonald's, and that's why I chose this, that doesn't go so well in the litigation scenario, you know. Other things, just trying to think of it. Delay, and again, I'm not even saying that's conscious, but a lot of people hit it with the, oh my gosh, it costs money. Oh my gosh, I'll think about it. But y'all know what a Tuesday's like. You're going to turn around, and the next thing is it's next Tuesday. And then it's 3 Tuesdays away. And all of a sudden, you know, you've had somebody file a similar trademark, and then you come back to the attorney like, time to go. And the attorney's like, time to not. You know, it's like, I've got some bad news. We got to figure this out.
Yeah.
So, but again, y'all, the main thing is, again, be honest with your attorney, even if it's uncomfortable, because guess what? You would rather be given the bad news by your attorney than by the other side. And then your attorney almost, they don't become an enemy, but they definitely are looking at you with a raised eyebrow going,
what else did you not share?
Yeah, that's right. You've stuck my neck out. I just got it chopped off. We need to have a heart-to-heart now. And it causes a loss of credibility. It absolutely
and it makes
does.
your job harder.
Absolutely.
Okay.
So at what point does somebody have to consider sharing this situation with the team, right? You're a founder, you're hit with this thing.
Great question.
And maybe if you're an established company, when does it get
Great question.
an all hands on deck kind of thing?
Well, first thing I'm going to say, it depends, because it's the lawyer answer, but a smaller, but seriously, a smaller organization that only had a couple principals, y'all going to tell each other immediately, hey, you know, Jenna's going to get it and go, JJ, you won't believe what we got in the mail. You'd sit down, you digest it. Now, if y'all have 5,000 employees, do you put it on an all points bulletin? You do not. You know, you're going to want to handle this, and again, a slow, thoughtful, non-panicked manner. because, hey, guess what? Some of these are crap. You'll have somebody send something that's just wasteful. And it's like, all right, this is just a waste of time. Now, you might have to do damage control.
Is it more just like a bullying
absolutely.
The bullying
and again,
tactic?
That is one of the offensive uses of it. If you want to try to stymie somebody in the market, if you want to try to push them back down, if you want to put a finger on them and maybe keep them from expanding so fast, completely your option. But again, if you do it with bad facts, they're just going to smack you in the face and be like, nope. And again, now that you've had this situation sort of undressed by the other side, it's going to be like, oh, wow, you were alleging and made all these allegations. Well, here are all my counters that are actually based in fact and yours aren't.
Yeah.
That's kind of a bad thing. And their attorney, too, is going to, they might posture and come back with you like, we'll be watching you.
Yeah.
But again, no, it's just they say it in that voice. It comes across. It's like a Harry Potter thing where you open the letter.
That's right.
We'll be watching you. It also means, from a distance because we don't like the way these facts worked out.
Right.
So that is my main thing for folks is you got to have that candor with counsel always.
Yeah.
And I get it. Sometimes it hurts and sometimes you don't like the advice. You're going to like it more than the bill when the attorney has to come behind you with a push broom to pick up the pieces. Other protections too, y'all, it's like you've got to think of it. And again, I'll tell you this, if it's not yours, don't touch it. If somebody looks at Hello Chaos on this podcast like, oh, I want to be Hello Chasm, or I want to be Hello Randomness, or Hello Frenetic Energy. No. No. That's like,
use your creative muscle.
It is. Go a different way. I mean, you nailed it on the head. Be creative and go a different way. Yeah. Influenced by it, that's fine. Mimicry, not cool. And outright copying, absolutely not cool. But that also falls true for any sampling music, taking lyrics from a song, copying stuff from a web page. Those letters of, hey, you did something bad, you need to say, hey, did I? That's your first question. If the answer is I did not, then you're going to respond accordingly. If the answer is like, maybe I did, tell your attorney. Figure out where there's a way to reach this middle ground. But again, if it's completely baseless and you're just like, I didn't do this, I don't know what's going on, tell your attorney that. Yeah. But say, hey, we were kind of influenced by this, or I definitely listed that from the website. What do we do? Allow the attorney to at least have that information. Okay. Because trust me, you might just get a bland letter, but there's a bunch more evidence on the other side we haven't seen yet. So you can't act like they don't know what you did. Right. You have to be like, attorney, let me tell you what happened and let's figure it out from there.
Okay.
I have one last question. You said on the previous episode that it's really important to get an IP attorney who's like in your field, right? Yep. But if the complaint is coming from somebody in a different area of business or a different category, I guess, like, do you have to then try to get somebody else on your team who is specializing in that category, or
like what, Jenna? Give me an example.
Well, you said an example earlier, maybe ours is a podcast, but theirs is a tractor company or something like that.
Oh, yeah. Would you need somebody experienced particularly in that area? Yeah. Probably for a cease and desist letter, not for the initial stages. Now granted, if it were a patent case and they're coming out saying, hey, this is your device and this is my widget, and you only speak podcast widgets and they're talking mining widgets, you probably do want to find, if not an attorney, an expert in the area who can say, hey, how do these two interact with each other? Because the IP attorneys, you should be pretty good about saying, hey, I'll tell you the waters I surf and the waters I don't surf. If they're saying they surf everything, just feed them to the sharks and be done with them, because that's not good. I'm just telling you, if I don't do it, I'll tell you it's out of my wheelhouse. I've got partners who will do it, but y'all, it's easier for me to sleep at night knowing that I'm not like, I can do all things for all people. It's like, hell no. What I can do is I can do a good job on the things I know, and if I don't know it, I'll send you to somebody who does.
Or specifically look for an IP trademark attorney.
Yes.
Not just a general counsel.
Absolutely. And not knocking a general counsel. A lot of them do a lot of things well, but IP y'all speaks its own language. When I say I received a 2D, everybody's eyebrow goes up because that means, hey, I had a trademark cited against my application. You need somebody who speaks that speak, because when you get that cease and desist letter, it's going to be speaking that speak. Right. And it's going to say Lanham Act violations, and it's going to say infringement. It's going to say treble damages. And you don't want somebody who is a real estate attorney, and again, not knocking them, they do a good job as a real estate attorney, but going to them with an IP matter is inviting chaos instead of trying to shield from it.
Yeah.
So do you should people just have, if you're starting a business, especially, a lot of our audience is going to be people who are maybe in their earlier stages and maybe didn't even know that they should be dealing with this stuff. Sure. So, what's a good, do you just kind of introduce yourself to an attorney and meet one without retaining them? How do you?
Yeah, absolutely. there's, tons of organizations will help you find a good attorney. Call the South Carolina Bar. Say, hey, I'm looking for an attorney in this area.
State bar, wherever you are.
Absolutely. Yep, South Carolina, Nevada, wherever you're at. Say, hey, I'm looking for somebody. And again, you can always go to the yellow pages, but remember, just because they're advertising doesn't mean they're necessarily good. Find out their reputation. And again, I'm not knocking the guys that advertise, but I'm saying that you use the client, do have some homework to do.
Right.
Because, hey, this is your attorney. It's not like, hey, this is my disposable fork. This is the person who's going to be representing you and protecting your IP. Make certain you're comfortable with them. Ask around, see what their reputation's like.
So other founders or CEOs in your category or just in your community that you're connected with, just say, who are you using to trademark?
Absolutely. And get you a few names and kick their tires. I mean, I encourage clients to do that to me all the time. It's like, hey, ask around, talk to other people, sort of get a job on this, because you need to make certain they're comfortable. And again, I stick to my guns on this. If the attorney's wanting to do everything remotely or everything via phone or everything via email, I want to make you a little hinky. If you want to meet your attorney, meet your attorney. The attorney, I'll be like, let's meet. Let's find a middle ground. Come to my office. I'll meet you for lunch.
Right.
Because if that person's handling your things, you want that touch. You want to be able to say, hey, I know what they look like in a police lineup.
Right.
Maybe you don't want to see him there, but I know what he looks like, or she. So y'all laugh, but honestly, we're getting that step in society where everybody's so comfortable being separated. And y'all, it's like the legal practice is not a separate thing. I mean, it is your business, and how we protect that or defend off whatever's coming at us. Make certain you've got a good rapport with that person.
Right. Well, I look at that as, not just IP and trademark and have an attorney that can help, but we also looked at this from a, contract attorney or general counsel to go help us get our legal language and our, and our how we do business and how we're getting paid and make sure our terms and stuff. And I can't stress that enough but those are two separate kind of skill sets.
They are.
Yeah.
And you will want an attorney who's willing to say, I don't do that. Because if the attorney says, I do everything, they're probably not really good at any of it.
Yeah.
And again, not slandering anybody specifically, just saying, hey, if it is a niche area, make certain they speak the niche.
Yeah.
But y'all, you raise a good point, though, JJ. It's like, look, these contracts and these agreements, you got to make certain you have them, just like your IP. If you don't have that, and God forbid, do not go to the internet and pull it down.
Right.
Because if you pull a document off the internet, you have no idea if it was crafted under a California auspice, a New York auspice, a Florida auspice. Because trust me, a California doc's not going to work so well in South Carolina, and vice versa.
Yeah.
So be very careful about that.
And that was kind of a lesson learned for on the marketing side of the business. When I started that in 2013, we got a general counsel and they just kind of gave us a draft contract, but we weren't savvy in how to defend the process.
Haggle.
And like the haggle, but also to the attorney, you need to hide behind. Like if you're nervous to, set it in front and they're like, that's your process. Be strong about it.
That's
and
right.
we got taken advantage of a client down in, I'm gonna say Florida.
She's like, never
gonna do business in Florida. But it was a big lessons learned for us. We were in our third or fourth year in business. It was like one of our largest, accounts as a $500,000 project of, with media, and it was we were doing TV spots and stuff, and they kind of did their first series of payments, and then they just stopped paying.
Sure.
And then we don't have to pay you. You're too small. You won't take us to court. And so, we had an attorney that, I called her and she's like, why did you do business? Like, you didn't vet them. And I said, but I gave them our contract. And she was like, but you were too loose on some of the terms. Sure. And this should have been your red flag. And I mean, so even just her counseling us of, there are companies that prey on small businesses, especially in the creative field, that bank on
that you won't sue,
you won't take them to court, you won't defend, the contract. But also it was just kind of our lessons learned with her that she sat and coached. Like, I would have never thought I needed to be worried about being preyed upon.
Yeah.
As an owner of a company.
No business ever wants to think that.
Yeah.
That they were like,
to think about.
Just would have never thought that. Or, hey, we got the contract signed. Like, I would have never thought they signed the contract. They agree. And then they just say, and I didn't even think about it. But, she kind of went through and coached us, our team to go, this is why these are things that you are, you don't compromise.
That's right.
On these milestones, these things. And when you do, then you hold back like the fight, like you've got to have your protection.
You do. You have to have something.
But that was, we were 4th year in the business, and we were literally getting coached, but it was because we had a great attorney, and she kind of made me nervous because she's, she was yelling at me of like, why did I? And I was like, I didn't know.
If there's an attorney that tell you they've never yelled at a client, they're lying.
Yeah. Well, she was, and I love.
So
I'm
you
like,
may get yelled at.
You might get yelled at,
but again,
but it's tough love.
But JJ,
it
that
was
message
tough
stuck
love
because here you are 4 years later going, hey, or after you're 4 saying,
Yeah.
hey,
6
this
years
is
later.
what I've learned.
Yeah.
And you're like, this stuck.
It stuck.
But it's all just like vetting your attorney. Vet your clients. There's absolutely nothing wrong with going out there and doing a search and saying, hey, what about these guys? All of a sudden the news articles pop up, fraud lawsuit, blah, blah, blah.
Yeah.
Maybe that's not who you want in business.
That's right.
So doing a little homework both ways counts.
That's right.
We should talk about that next time.
Yeah.
Yeah. Man, we're out of time, unfortunately.
I've survived another one. Awesome.
That's like,
Okay, this was awesome. So, 2 things. Just what are some, just like a last bit of advice, and offense, defense, whatever, and
don't panic. When you get this, hey, there's awesome ways to handle
Drink of water.
it. That's right. A drink of water and a little calm. Do not respond back in anger. Church language only. Then go find your attorney. Y'all laugh. I literally tell folks when they're enforcing their march, they're calling out, I want to hear church language. And I have a mouth like a rabid sailor, so I understand hypocrisy. But I don't want to hear my clients mimicking me on a call to someone else.
That's right.
But as far as an offensive one, don't be afraid. Guess what? It is your mark. It is your blood, sweat, and tears that are making that brand awesome. You do not want someone to damage it simply because you were too lazy or too naive to go out and take a little action.
or too nice.
Awesome.
Or too nice.
Yeah.
Absolutely.
Nice. So the advice is just be nice.
Yes.
Or don't be so nice.
Well, know when not to be nice.
There you go. There you go.
So-
There you go. So, Burr & Forman, where do we find you?
Anywhere.
For more
there's 400 of us. We were just
Okay.
kind of hanging at Dodge bars, McDonald's parking lots.
How do
whatever we
people
do.
continue the conversation with Doug?
Absolutely. Burr & Forman, we're actually a Southeastern Forum, about 350 of us now. We stretch from, I'm trying to think I can get this right. I'm going to offend somebody because I'll forget. We stretch from Mobile all the way up to Delaware now and just keep adding to it. But we are really a Southeastern firm. Downtown Greenville, 104 South Main Street. Again, you can Google, you can find us.
And it's B-U-R-R.
I call it Cocklebur. That's exactly it.
right.
B-U-R-R and Foreman, F-O-R-M-A-N. Not the boxer, though, so don't get confused.
Okay.
But, anywhere, and again, same concept, vet your attorneys, check them out. You can look us up online. You can go to our website, burrforman.com, and find out what we do to see if it's a good fit. But I advise everybody watching this podcast do that. Check your attorneys out because it is a close relationship.
Yeah.
Awesome. Well, thank you so much. This has been great. And where do people find us?
So you can find our podcast anywhere at your favorite podcast platform, or come to Orange Whip. That's orangewip.com. And there's a Hello Chaos page, and you can either choose to listen or watch.
I recommend
entertaining.
watching. We're beautiful. All right. Thanks, world.
Thank you.